As an attorney, I firmly believe that due process is as essential to American jurisprudence as air, food, and water are to life. It is a constitutional guarantee that requires access to all of the evidence that the government has against a defendant. Due process provides that the government must follow fair procedures and ensures fundamental fairness when taking actions that could impact these rights. But if we're honest, we know that our system falls short far too often in the delivery of justice to Black and brown New Yorkers, culminating in a prison sentence system that is just us instead of justice. Prosecutors, let's look at the facts. In the 5 years since the reforms were enacted, there has not been a single wrongful conviction that led to an exoneration in New York State involving exculpatory evidence being withheld. And that's according to the National Registry of Exonerations. A 2020 report issued by the Brooklyn District Attorney's Conviction Review Committee found that 25 exonerees served a total of 426 years consecutively. Collectively, 45% of the wrongful convictions were the result of the non-disclosure of evidence. 96% of those exonerees were Black and brown. Guess what? Justice or just us. These wrongful convictions occurred before the discovery reforms were even enacted. It is important to note that the present changes that the prosecutors must still turn over complete and robust discovery, not only what's in their actual possession. Secondly, the Speedy Trial Statute, CPL 3030, still acts as the enforcement mechanism to ensure early and complete discovery. Prosecutors cannot announce that they're ready for trial without a valid certificate of compliance attesting that they have met their discovery obligations, among other speedy trial requirements. Courts will still use the objective due diligence standard. While they can consider whether any late discovery resulted in prejudice to the defense, it can never be the sole determinative factor, even if it can't be demonstrated. Courts must still ensure that prosecutors do not play games with the speedy trial clock by filing empty certificates of compliance. While the amendments require prosecutors to state known material that they have been unable to obtain, courts must still evaluate whether their efforts satisfy due diligence, which refers to all reasonable evidence to provide exculpatory evidence to the defense, and that includes whether they should have known about missing materials or misleading materials. Most importantly, due diligence cannot be satisfied merely by disclosing what prosecutors have obtained or will obtain. I want to emphasize that these amendments have not changed the basic premise of discovery reform. What is in law enforcement's possession is still deemed to be in the prosecutor's possession. While one of the many due diligence factors includes the court's ability to determine what is significant, prosecutors may not and should not make that determination. By changing the qualifying language in some of the individual categories of 245.20, we are not granting prosecutors that gatekeeping function. In fact, related to the subject of the charges is hardly distinguishable from related to the subject matter of the case. This matters in some contexts. Perhaps, for example, we acknowledge that if a search warrant was conducted, disclosure is warranted even if it was issued and resulted in the arrest and prosecution in the instant case, for example, the charges. Without the accompanying safety valve that requires prosecutors to respond to defense inquiries, the defense's ability to ask for extensions of time, and the requirement that prosecutors still file their certificate of compliance in good faith, I could not in good conscience vote to pass the budget. However, I hope that the concessions made in discovery do indeed preserve the original intent of the 2020 law, which is even-handed delivery of due process to every accused New Yorker, no matter what their zip code is.